Alex here with a legal nuts and bolts video on mid-case termination. So I did a video on early case termination quite a few weeks, maybe even a couple of months ago. It was a video that I knew I was going to end up following up with this video, mid-case termination, because these are things that occur quite frequently in the court system, especially when it comes to non-attorneys. The early case termination focuses on how cases are defeated early on because they were never really cases to begin with. That's the best way that I could explain them. Is somebody filed a complaint or a petition and they alleged, you know, a series of allegations, and those allegations, even if true, would really not entitle you to any relief. There's a variety of ways that it can occur, and it's discussed in the video early case termination. And as I mentioned in that video, we live in a country where people are of this idea that they have a right to their day in court, but at the same time, that saying, which is very popular, does not at all, I think, explain the reality of what it does to the people who are the targets of the lawsuit, which is not just a money sort of drain on them because they will typically have to hire an attorney unless it's like a small claims case, but also the time and the stress and the anxiety that it gives the targets of the lawsuit. And so, yes, people are entitled to their day in court, but early case termination explains that you actually have to have a case of some kind that the government can even do anything for you on. You don't just get to file a piece of paper and drag people into court just because you feel like it and you're upset. There has to be some law that was violated, and there has to be some damage that was done. And I'm speaking in generalities. There's oddball types of situations out there, different types of case that don't really fit into the mainstream sort of lawsuit. But generally, the idea is that you are not entitled to your day in court if you don't have an issue that the court can do anything about. And early case termination explains how attorneys, and I guess non attorneys can do that too, it explains how they can destroy, kill, shut down, toss out, whatever word you want to use, a case very early on in the process rather than having to go all the way to the end, which in some situations can involve a jury trial, which is extremely expensive. I think even if you don't have an attorney, maybe just in the sense of time and research that you're going to have to put into the jury process, which is a colossal area of law. Um, so this video, mid-case termination, kind of builds upon the principles discussed in early case termination, but it's a little bit more fuzzy at this point because now the evidence is being gathered. And so the point at this juncture is really that yes, there is a case potentially. They have at least made the allegations that would entitle them to relief if true. However, for reasons connected to evidence and whether or not there is a genuine issue of material fact, that's a magical phrase that I'm going to talk about more later, um, there may not be any need to go to trial. And that is the objective of attorneys in the mid-case termination process. The mid-case termination sort of approach. The defense would be trying to actually use these principles to shut down a case before it gets to trial, and the plaintiffs would be doing the opposite, trying to show that there is a genuine issue of material fact, and that since there is one, we get to go to trial. Um, Most of my videos, and I mentioned this in early case termination, I didn't just rehash everything that I'd already stated. I also cited several videos that I created that were consistent with the sort of foundation of what I was talking about in that video. In this video, there are also videos that I've already done that I'm going to reference now that I'm not going to repeat myself on. That was the point of doing those videos, so I wouldn't have to repeat it. Those videos are, let's start with the discovery videos. So we have one titled discovery, there's one titled request for admissions, there's one titled interrogatories, there's one titled request for production of documents, there's one titled subpoenas. I believe there is one titled depositions, pretty sure about that. And I think subpoenas ducus tecum are covered in the same video, the subpoenas video. So that should be all of the discovery instruments and the general discovery video itself. Then you should also take a look at the video summary judgment. And that video talks about how an attorney can go to the court and say, based on the pleadings that were filed and based on the discovery that has been done, there is no genuine issue of material fact for a jury or the court, if it's a bench trial, to decide on, and therefore we should get a judgment right now in the middle of the case. So this case has gone past early case portion, the early case termination, sort of discussion area, but it hasn't made it to trial, and it's not, going to, because of what I just said earlier, is that there aren't any genuine issues. All I can say, there is a wealth of case law on this. You have to do your own research. But all I can say is that it very strongly hinges on the discovery process. That the plaintiff, from what I have looked at in the case law, speaking in generalities, you should do your own research, the plaintiff has some serious obligations at this juncture to conduct discovery, to conduct depositions, to go and issue these subpoenas and these requests for admissions and these interrogatories. And if the plaintiff doesn't do that, it can be very easily held against them when the other side says, we should get summary judgment. And here's why. They've made these allegations and they haven't even raised a pinky finger to try and find out if any of this stuff is going to be an issue for a jury. I have seen some case law where it looks like one side thinks they're just going to get a trial because the allegations are there, and the other side says they haven't done any discovery. They haven't even tried to show that there's an issue. And that seems to me is something that works. Sometimes the plaintiff will actually win on summary judgment. It's interesting, but sometimes discovery questions are issued, the discovery instruments are issued, and it turns out that the areas of the genuine issues of material fact have been resolved in the discovery process, and that there may still be questions of law for the court to decide who's going to win, but there are no longer any genuine issues of material fact. And so sometimes the plaintiff actually wins on summary judgment. They basically say there's no need to go to trial because this is really just down to some issues of law. They've admitted these facts. So since they've admitted them, or since we figured them out, we don't need to bother with a trial. Let's just decide this now. And so it's not always used by the defense to throw a case out. It's also sometimes used by the plaintiff to win a case very early. The other thing that I would like to mention is it seems to me quite often that even though summary judgment is not completely effective, that there are some claims that are resolved early on in the summary judgment process. Maybe they can't get summary judgment on all of the claims, but they can on some of them. And so it goes to trial and it gets sort of whittled down to the issues that remain, the claims that still have genuine issues of material fact. So it's interesting to see how this process can be used to sort of simplify things for a jury, in the sense that now, instead of having to consider 10 or 11 claims, they only have to consider 2 or 3 because the other ones were dealt with in the summary judgment process. The issues were terminated mid-case. As I mentioned in the video, early case termination, try to understand that you are dragging all of these people through the legal process, not even just the targets of the lawsuit, but even the attorneys, the judge. They're busy, they have a lot of cases. And so this is, as I mentioned in early case termination, this is putting on the person that's prosecuting the action the obligation to really go and show that there is a point to the trial, that there is a point to bringing all of these people into this room to decide this issue. And I think that it helps people to understand that this isn't just something that's sort of meant to pick on them. I talked about that in the video early case termination, where a lot of self-represented people feel like it's unfair and it's just picking on them for not knowing how the law works. And that's mainly because I think a lot of people have just seen a lot of Judge Judy, and they just see people walking into court and just talking. And so they just think that's what they're going to do. They're going to just walk into court and talk. And that's just not how it works in the real court system. The process is formal, there's a procedure. You don't just go get to walk in and talk unless it's a small claims case. And that these processes are a way for not even just the government and not even just the court system, but society. Even society really does not favor the idea of filing lawsuits willy-nilly and dragging people into court. People just don't like the sound of that. And so you can get to the courtroom, you can get to a jury trial or a bench trial, but you have to do some work. You can't just say, hey, I got butt hurt and I'm offended and so I'm suing. No, it's not good enough. You have to show in the early portions of the case, you have to show that you have actual legal claims that the court can even do something about, which means you have to allege things that, if true, would entitle you to relief, and you have to at least allege that you were damaged in some way, in a way that the law recognized, not in the way that you just personally feel. It has to be recognized by the law and by society. And then if you can get past that portion, then you are also expected to at least do the heavy duty lifting necessary to show that you are actually trying to prove your case, that you're actually going through the discovery process and you're putting in the effort to show that you have genuine issues of material fact. I think the last thing that I will mention kind of dovetails off of that. And it's really important to not think of discovery as the process to actually prove your case. Some people, especially non-attorneys, think that's the point. It's like, okay, I'm going to use these discovery instruments to ask these obvious questions about the case, and the other person's going to admit them and I'm going to win. Or they're going to lie, and I guess they just didn't think that far ahead. But really, it's not used. I mean, some of the questions in discovery asked are along that line, but a lot of them are focused on trying to find out what your strategy is going to be and trying to sort of narrow that down. So on the one hand, yes, it's about proving your case, but on the other hand, it's about cutting off certain approaches that you may take in your case, or at least finding out what it is that you're going to say. And so that is one of the ways that the attorneys focus more on eliminating genuine issues of material fact and sort of proving the actual case into sort of a secondary a slot. And the reason why is because summary judgment is typically the mechanism of mid-case termination, and summary judgment is very heavily based on discovery. In fact, I've seen some case law indicating that summary judgment is denied when it's filed too early and not enough discovery has been done. It just basically because the other side is saying, we're not done with discovery. How do we know if there's genuine issues of material fact if there's still time to find out if there are through the remainder of the discovery period? And that's one of the things that I've seen pop up. Sometimes there are other ways to defeat a case in the mid sort of section, maybe even early. I'm thinking of anti-SLAPP right now. That's why it's kind of fuzzy. It's like between sort of those two phases, and that occurs because the legislature says so. Sometimes the legislature will create a statute, and that creates, as defined in the statute, a way to terminate a case early on. The two examples I can think of, one is anti-SLAPP, which I just mentioned. Those are strategic lawsuits against public participation, and the legislature in Nevada and other states has created a statutory scheme that explains how you can force the court to conduct some fact-finding very early on to shut a case down very early on under certain circumstances, very closely connected to freedom of speech in the First Amendment. Other mechanisms created by statute are I believe medical malpractice and I think professional negligence claims. I believe that they may be the same thing, guys. I'm not an attorney, and I've seen these phrases come up, and for all I know, medical malpractice is sort of a subset of professional negligence. I don't know, guys. You can do your own research. But the point I was going to make is that there are statutes created by the legislature that indicate that certain affidavits have to be filed by experts in those fields, where allegations are being made. And if those aren't filed, then that creates a new way for an attorney to throw a case out very early on. So I sort of speak in generalities when it comes to videos like this, but keep in mind that your legislature in your state may create exceptions to the generalities. They may create statutes that empower somebody to do something that generally they wouldn't be able to do, but now because of the law they can. And so those are two ways that cases can be defeated, and that's just because there's a statute. So if you have any other questions, feel free to post them down in the comments below. and I will see you guys next time.